Judge just granted a request by former President Donald Trump's legal team to appoint a special master to review documents seized by the FBI during a search of his Mar-a-Lago estate last month.
A federal judge granted former President Trump's request for a special master to review the documents seized from Mar-a-Lago last month.
Some important breaking news just in about the federal case against Donald Trump. A federal judge granting the former president's request for a special master, a third party, to review the material the FBI took under search warrant from his Mar-a-Lago home.
So let's talk about what's going on. All right, people. Last time I saw you, we were looking at the affidavit in support of the application under Rule 41 for a warrant to search and seize. Now, this document was highly redacted. More than half the document was redacted. And the Trump team then later asked for a special master. So that special master has been granted, but not appointed. So we're going to talk about what's going on and what the legal issues are involved with this special master ruling from the judge. So we now know a little bit more about the timeline from the filings when it comes to the special master. So here's a quick recap. Trump sent 15 boxes of materials to the National Archives. The National Archives looked through those boxes and found classified information within those boxes. The National Archives then sent those boxes to the Department of Justice, specifically the FBI. FBI looked inside them and said, hey, there are government records and top secret documents within these things. They then sent a couple of requests to President Trump asking him to turn over any other classified information or any other information marked classified back to the government. President Trump failed to comply with these letters. So the Department of Justice then went to a grand jury and asked for a subpoena to force the former president to turn over any classified documents, particularly any documents marked classified. Here is the subpoena. It reads, any and all documents or writings in the custody or control of Donald J. Trump and or the office of Donald J. Trump bearing classification markings, including, but not limited to, the following. And they list all of the different top secret markings and classified markings and whatever. So with this subpoena, they sent it to Trump's team and said, please turn over everything, comply with this subpoena, anything that has any of these markings. Well, Trump's team then sent a whole bunch of documents that had those markings to the FBI. The FBI then asked, well, is this all of the documents that are marked classified that are being asked for with the subpoena? President Trump's attorneys said, well, yes. Matter of fact, we are so confident, we're going to give you a sworn certification stating the following. I hereby certify as follows, Trump's attorneys. I have been designated to serve as custodian of the records for the office of Donald J. Trump for the purposes of the testimony and documents subject to subpoena blank. I understand that the certification is made to comply with the subpoena in lieu of personal appearance and testimony. Based upon the information that has been provided to me, I am authorized to certify on behalf of the office of Donald J. Trump the following. A diligent search was conducted of the boxes that were moved from the White House to Florida. The search was conducted after receipt of the subpoena in order to locate any and all documents that are responsive to the subpoena. Now remember, it's important. The subpoena said anything that had classification markings on it. You know, what I feel like it's, if they're marked classified, if the document has classification markings, you're supposed to turn them over. C, any and all responsive documents accompany this certification, and no copy, written notation, or reproduction of any kind was retained as to any responsive document. I swear or affirm that the above statements are true and correct to the best of my knowledge. Dated June 3rd, 2022. So, FBI asked, Trump's team says, yes, we don't have anything else. It's all gone. You have it all. Anything that's marked classified. But there was a confidential informant that said, we still have top secret documents here at Mar-a-Lago. There are still things marked confidential that are still here. And all the information about who this person is, how they know what they know, is redacted on the search warrant affidavit. But allegedly, this informant gave the information to the FBI. So the FBI, after asking multiple times, after sending a subpoena, said, well, maybe a search warrant is appropriate because they're just not turning everything over. They're not responding to the lawful subpoena. So with the help of the snitches, they asked a federal judge for a search warrant. Now, the basis of the search warrant was the violation of these 3 laws. Let's go over them in kind. First, 18 U.S.C. Section 2071, which is the concealment or removal or mutilation in general of any government document. Could be a tax return, could be a social security card, any government document that belongs to the federal government, and you can get up to 3 years in prison for that. If that same document has anything to do with the national defense, then you can get up to 10 years for concealment, removal, mutilation, or anything else illegal under this law. And then last but not least, you have 18 U.S.C. Section 1519, where if you conceal, remove, or mutilate any government document with the intent of obstructing justice, you can get 20 years in prison. Now, the most interesting part about this is the government doesn't have to prove the documents are top secret or classified. They just got to prove that they're government documents. Here it is on the affidavit. 18 U.S.C. Section 793 does not use the term classified information, but rather criminalizes the unlawful retention of information related to the national defense. The statute does not define information related to the national defense, but courts have construed it broadly. And they put all of this wonderful case law to let you know that the documents doesn't have to be classified. They're just any government document relating to national defense. So the warrant was based on these 3 laws, that Trump was not authorized to have this U.S. government property, and they know this because they had a confidential informant tell them. So Alan Dershowitz, who was Trump's attorney during his second impeachment, believes that there is sufficient evidence to indict Trump in the redacted affidavit. He says this: any grand jury in D.C. would indict Trump on the evidence that he had classified materials in violation of various statutes, Dershowitz, 83, told the Post by phone Saturday, but cautioned the Department of Justice from pursuing the case. And his attorneys have some real issues as well. They could end up behind bars or facing some criminal liability. And their criminal liability has all to do with the certification that they said they not only searched, but they turned over all responsive documents to the subpoena, all things that were marked classified. They certified under oath that this was true, that they had given everything over. And then on top of this, when the federal government, the FBI asked, well, could they look at the boxes? Can they look in the storage room? Can they look to see if there's anything left? The attorneys said, no, we've given you the certification. We don't have anything. And remember what they were certifying to. They were certifying that they had turned over all documents bearing any of these classification markings to the FBI. And now we know that they didn't. After the search, the FBI literally found hundreds of documents with these classification markings. So just so we understand, the attorneys, by signing that certification, essentially have lied to the FBI and could also be charged with obstructing justice. Remember, they did a detailed search and didn't even allow the FBI to go look. They now have criminal liability. And it gets worse because they may be involved with the criminal activity itself. That eviscerates the attorney-client privilege with what's known as the crime fraud exception. If the lawyer is involved in the crime, in this instance, hiding government records, then that destroys any attorney-client privilege because the person wasn't acting as an attorney, but as part of the criminal conspiracy. So the big question is, why was President Trump holding these documents? Why did he need them? It doesn't make any sense. Here is one of the anchors from Fox and Friends in the Morning asking that same question. Check it out.
Well, ultimately, it comes down to why did he have all that secret stuff at Mar-a-Lago? You know, I know his team has said that they declassified it, but that's news to the agencies that those documents belong to. And Governor, he had apparently 3 classified documents in his desk. And then the stuff, as Brian detailed on the floor, it shows 5 yellow folders marked top secret and another one that says secret SCI, which means sensitive compartmentalized information. Those are the biggest secrets in the world. Why would he, and apparently the former president went through them in January, why wouldn't he say, oh, you know what? I really need to turn that back over. Why did he have all that stuff at Mar-a-Lago?
Well, that's why I think it's important that this is transparent and that we do have someone who's outside of the DOJ looking at this and talking to people. What is this information? We don't know what was in there. We don't know. Believe President Trump declassified all this information. Let's find out really what the process is, what is right, what's precedent that other presidents have followed, and make sure that this is done correctly.
Governor, I don't think any president has ever carted off that many documents to their house after they left the presidency.
Well, there was no secret. I mean, it was out in front. We've seen the video. I mean, there wasn't, if he was trying to conceal something, he did a pretty terrible job because you see all the boxes and the hand trucks loading onto the chopper.
So now we have a fuller picture that the Department of Justice sent letters, they did a subpoena, and then eventually had to issue a search warrant to get the documents that were still at President Trump's compound in Florida. And now TMZ is reporting that some of those documents, the top secret documents, included nuclear secrets. Now, one of the things that's crazy about TMZ is a more trusted source than, let's say, the New York Times and the Wall Street Journal. That's crazy. So now that we've looked at the background of all this stuff, let's talk about the special master. That means we're going to have to also talk about the judge's ruling. So this is Judge Cannon. She's a Trump-appointed judge. Now, I've read her ruling, and there are multiple issues with the ruling. Now, let me explain to you what I believe are the fatal flaws within her opinion. Okay, so the first issue with this opinion is that the issue is essentially moot. See, the role of the special master in this case was to look at the documents before the government was able to. So if you had a letter in there that was attorney-client privilege, then the special master is essentially protecting President Trump from the government looking at that document. But now, since the government's already looked, then the special master's role seems to be non-existent. Now, I understand the court may want the special master to just review the government's work, but then that's not really the role of the special master in this particular instance. So essentially it doesn't make sense because the court's appointed somebody to look over documents before the government has looked over the documents, but she's appointed that person after the government's already looked over the documents. It doesn't work. Now, don't take my word for it. Here's Trump's former Attorney General, Bill Barr, explaining it on Fox News.
I'm not sure you need a special master to identify it, but what people are missing is that all the other documents taken, even if they claim to be executive privilege, either belong to the government because they're government records, even if they're classified, even if they're subject to executive privilege, they still belong to the government and go to the archives. And any other documents that were seized, like news clippings and other things that were in the boxes containing the classified information, those were seizable under the warrant because they show the conditions under which the classified information was being held. So I think it's a red herring. I think it would, at this stage, since they've already gone through the documents, I think it's a waste of time.
So the second issue I have with the ruling is the separation of powers issue. See, the court generally doesn't have the constitutional authority to stop the executive branch from investigating something. And that's essentially what the court did here. Here is former Judge Andrew Napolitano explaining it.
She has stopped the prosecutors from conducting any part of the investigation that relies on what they obtained from the president's home. That is a violation of the separation of powers. That is the judicial branch interfering with the executive branch. The remedy is for her or whoever the trial judge is, if Trump is indicted and there is a trial, to bar the use of the documents at trial. But judges are without authority to bar the use of the documents during the investigation preceding trial without violating the separation of powers. The judicial branch trampling on the inherent core rights of the executive branch. So we don't know where this will go. Looking at it from President Trump's point of view, this will delay the investigation.
Now, my last issue with this ruling is that the judge made a big deal about the executive privilege piece of it, and that allegedly some of the documents could be returned back to former President Trump because of executive privilege. Now, I'm going to say, even if a former president could exert executive privilege over some of the documents would still be government documents, and they would belong to the federal government, not former President Trump. Remember, President Trump is being investigated for taking government property. So claiming executive privilege is essentially saying this is government property. But he's saying that I'm allowed to have this government property. But that wouldn't really have any bearing on whether it was government property or not, right? You can say they're executive privilege, okay, but that still allows the government to take that property because it's government property. Maybe Bill Barr can explain it to you a little better. Here he is again.
But what people are missing is that all the other documents taken, even if they claim to be executive privilege, either belong to the government because they're government records, even if they're classified, even if they're subject to executive privilege, they still belong to the government and go to the archives.
My thoughts. Well, I think the ruling was bad on both the law and the logic and is very vulnerable to appeal. Here are Andrew Napolitano and Bill Barr saying the same thing.
So where does this go from here? I expect that the feds will appeal this decision within hours, and that the 11th Circuit Court of Appeals, which sits in Atlanta, will enjoin it. This is an amateur decision written by a federal judge using the appropriate jargon, but there's too much language in there about her personal evaluation of the believability of the lawyers before her, which is not the role of the federal judge here. The lawyers are not testifying, they're just making legal arguments. Secondly, she has stopped the prosecutors from conducting any part of the investigation that relies on what they obtained from the president's home. That is a violation of the separation of powers. That is the judicial branch interfering with the executive branch. The remedy is for her or whoever the trial judge is, if Trump is indicted and there is a trial, to bar the use of the documents at trial. But judges are without authority to bar the use of the documents during the investigation preceding trial without violating the separation of powers. The judicial branch trampling on the inherent core rights of the executive branch.
So you think the special master will be overturned on appeal by the DOJ?
I think if DOJ appeals eventually, it'll be overturned.
How long will that take?
Well, that's why it could be delayed. I hope they expedite it, but it could take several months to get that straightened out.
Now, next, I really don't care about the special master reviewing the documents. I think that doesn't really bother the process or mess anything up. But I do think that enjoining the government from continuing to investigate criminality based on what they've already seen is a violation of the separation of powers, and I think makes this judge's ruling extremely, extremely vulnerable to being appealed. Now, this Friday, the judge is asking both sides to submit lists of possible special masters, which I think is going to be a little more difficult, especially concerning the high level of classification that that person is going to need to be able to obtain to review, the highest level of top secret documents that we have. And, both sides are going to have to probably agree on this third party. So that's going to be a difficult thing to do. But I have two questions for you. Number one, do you think the government should appeal this order by the court for a special master? Do you think this was a legit ruling? Do you think that we're wrong about our feelings that this ruling was just bad and very vulnerable to appeal? Let me know in the comment section. My name is Nate the Lawyer. I'll see you next time. Peace.